I could ask the councilors to take their seats. This is the meeting of the Ad Hoc Committee on Medical Marijuana. On the subcommittee, joining us tonight, Council Gould, Council Turco, Council Walsh, and I'm going to ask Councilman Sulis if he would sit in for Council Gravel. Thank you. When we last had our last Ad Hoc subcommittee meeting, we talked about some of the criteria, how do we want to go forward with this. So what I'd like to do is make some suggestions and then open the floor up to any other councilors. Sure. So what we've done is, just to recap, is that I'd like to ask all three parties to come in to make their presentations. As I stated before, I think previously, the City of Lynn gave each party, when they did it, 12 minutes. To be quite frankly, that was a little bit rushed. I think it wasn't advantageous to, anybody. I think the people making the presentation wanted the opportunity to say a little bit more. And so with that being said, after watching the hearings, I'm going to make the recommendation that we let each party have up to 25 minutes for their presentation. After they make their presentation, I would then like to leave some time immediately after each presentation that the councilors could, any Q&A of approximately 10 to 15 minutes. If we really feel that, it needs to go a little bit further on the Q&A, I won't cut it off, but I think, 45 minutes for each group is plenty of time between presentation and Q&A. So that's my first recommendation, and when we're done, I'd like someone to I think we probably should make a motion from the floor on that, and that would be on the presentation. That would be at the next council meeting, which would be Thursday, November 9th. For the record, and I printed a lot of papers today, and I apologize, we have 3 applicants, and Tim, excuse me. We have three groups. We have Sanctuary Medicinals. I'm going to let the clerk say it because he rather than say it incorrect.
I believe it's Sanctuary Medicinals, HR Development, and Phytotherapy, if I'm saying it right.
There are 3 parties who've submitted requests for letters of non-opposition. After the presentations, we'll close the hearing, and then on the 16th, the following Thursday, we'll then come back and vote as a council. And each councilor can vote up to 0, 1, 2, or 3. You can vote once again for 0, 1, 2, or 3. The most important thing to understand is that as long as a party gets 6 affirmative votes, they will then get a letter of non-opposition from the City Council, and then they will be able to go forward to the state. They go to the state does their due diligence, they have to get some permitting done there, and then they come back to us for a special permit hearing. And from what I've been told, that's not something that this council, the way it sits today, unless, well, it won't be the same because a few people are moving on, but that would not be, the special permit hearing would not be heard by this council because it does take a period of time. So when they come back for the special permit hearing, that would be sometime most likely in 2018. And then, and that's basically it. So I just wanted to kind of give everyone a little bit of a background and overview. At this point, I'd like to open up the floor to any councilors who might have any questions. I did ask City Solicitor Smazinski to be here if you have in case there's any questions I might not be able to answer, and we'll go from there. I'm going to go Council Walsh, then Council Gould.
Thank you, Mr. President. So just so I'm clear, the presentation for each party is 25 minutes, then with a 20-minute question and answer, so it's a total of 45 minutes each?
Correct.
Okay. All right. And I guess the other piece of it, when you said that if the council as a whole will meet to decide whether each member is voting affirmative or not, and that equals the letter of noncompliance if you get 6. I guess the question is this. So the committee is just to establish the rules, but the presentation is to the entire council?
That is correct. The presentation will be in the regularly scheduled portion of the meeting to the entire council, correct?
Okay, so the committee's job, I guess, or assignment will be completed this evening?
That's my expectation, yes.
Okay. All right, thank you.
Council Gould?
Thank you, Mr. President. Just if you could help me clarify, and if Mike, if you need to chime in, please do. Mr. President, when we hear the presentation from the 3 groups, do we vote yay or nay on Group 1, yay or nay on Group 2, yay or nay on Group 3? Is that how you envision us?
Yes, that is the way it would be.
And so
Exactly. That vote would not take place on the 9th. Council would
Correct.
take place on the 16th, correct?
So the vote will be after each presentation, or we will hear every presentation? We will hear every presentation and then have a period of applicant A, applicant B, and we'll vote, applicant C, and we'll vote?
Not quite. We'll hear every presentation on the 9th,
Yeah.
and then we'll recess the
I'm
hearing.
sorry.
And then we'll
Correct.
come
You
back a
said
week
on the
later.
16th.
And then
So-
we'll take a vote on
so
each presentation the way they were given.
On the 16th.
Excuse me, on the 16th, right.
You will ask for a vote of applicant A, applicant B, applicant C.
Correct. I will ask for, the city clerk will ask for a vote for a letter of non-opposition
Okay.
for each applicant. And a yes vote will be considered a yes vote for the letter of non-opposition.
Okay. Mike, you mentioned, Mr. Smazinski, sorry, you mentioned before that they will then go to the Department of Public Health, and I'm not quoting you, and I don't know if you actually said it, but we talked in generalities about the first one back with their approval by DPH. Is that accurate, Mike?
Each applicant armed with a letter of non-opposition or support, which has been determined to be equivalent by definition, even though the 2 terms exist in the Code of Mass Regulations, will entitle each applicant to go before the state and seek a certificate of provisional registration. And once that's in hand, that is a prerequisite for them to come back to the council and apply for a special permit. And, to answer your question, it's unknown what the timing is going to be in terms of, who can get through that process at the state and be in a position to return to us in compliance with the prerequisites of our ordinance.
So that being said, if all 3 come back and they're spaced out 2 to 3 weeks at a time, because I don't think that the Department of Public Health, I could be wrong, but they're going to receive applicant A and do their due diligence on that and make a determination. They're not going to know, or are they going to know that we have 3 applicants, that we've all, for instance, if we give 3 applicants a letter of non-opposition, will DPH take into consideration that Peabody has 3 applicants and we need to process them all together or individually? Or how is that going to work? Or maybe you don't know, Mike, I don't know.
That type of advocacy is left for the applicants that are second and third in line. I can envision, without knowing for certain, that the representatives for number 2 and 3 in line are going to go to the state and say, hey, listen, we're not far behind. We were all issued letters on a process that, emphasized equality and fairness. We should be on the same track. I can envision that happening. But again, this is a new process. And it makes sense, that you and I are now talking about, a management of that issue in a certain way, but I don't know what's going to ultimately happen.
Thank you, Mike. You may not know this, but maybe, Mr. President, maybe you do. I heard that there are only 7 medical marijuana facilities that are going to be permitted in Essex County. Is that true?
I don't know the answer to that. Do you happen to know?
It's limited right now.
Is it 7?
Yeah.
Yes.
Okay, so, not to speculate, but it would be shocking if they approve 3 in one site, or could they approve all 3 and in their minds, they're letting Peabody City Council determine of the 3?
Just base logic would dictate, a sense to achieve geographical distribution within a county. So I'm sure that is a major factor. And I'm not sure and can't speculate as to the extent to which the state ever envisioned having 3 places with letters walk in the door and saying, we're all at arm's length from one to another, please decide. It's the functional equivalent to what we experienced with, the Sonic and Alfie billboards. Probably didn't expect it to happen, but, the unusual does, unveil itself. So, I guess you have to resolve it here that, that's left to them to deal with. And
Them being DPH.
yes.
Council Turco. Sorry,
That's okay. I'm not, it's not that I'm uneasy about the letters of opposition, but we have to make sure that we are doing the right thing in making the decisions. I mean, these are people's livelihoods. These are folks that are investing serious dollars. And I'm not saying that we're not going in the right avenue. I feel a little better after hearing Mr. Smoczynski talk about the process, but we have a lot of at stake. We have to make sure that we're doing the right thing, and I think the slower we go, the better we are. So I have no further comment. I think we're going down the right track. But Mike, feel free at any point to bring us back on track if we're not.
Having vetted the suggestions made by the council president with the mayor and Mr. Sasslaw, what I can tell you is that, that proposed, matrix, that format is consistent with our ordinance. It's consistent with state law, both the regulation and the general laws. It's fair, and it gives this council the greatest level of flexibility to make the inquiries that it wants to make, and the time, because I think there's wisdom in taking in all the information but coming back a week later after having digested it and having some considered reflection, and then having a debate and deciding how to vote.
Thank you. I did leave out one piece of the puzzle. I apologize. I just don't want to make any assumption. When they come back with the approval from the state, not do they only need a special permit, but most importantly, they need to negotiate a host agreement with the mayor, who then will share that with the council, and has let me know that he will gladly take input from the council. But that host agreement is a critical part of it too. So not just a special permit, but they have to negotiate a host agreement with the mayor, and that host agreement will be transparent and known to all of us before you vote on the special permit. Councilor Turco and then Councilor Manning.
Thank you, Mr. President. I kind of, on the same lines as Councilor Gould, have some concerns with, first of all, the time frame. As far as 45 minutes, I do get 25-minute presentations. I don't want to limit myself to 20 minutes of Q&A. As you see, Tom just spoke for 10 minutes with just a couple of questions. And I know that this process could get lengthy, but I can only base it on what I watched today was the Melrose committee hearings with Mayor Dolan, and they did these very same interviews with some of the same companies. And some of those went on for an hour and a half, and rightfully so, because like Tom said, we're making very big decisions here. And I just wonder if, you know, to set a 25-minute Q&A period where one counselor may exhaust most of that, why is there a set limit on Q&A? If I need to ask another question, I should be able to ask it. And I don't want to be set aside and not get that question in because of a time constraint that we set ourselves when there's no need to set it. Secondly, again, back to Melrose and Mayor Dolan, and I know we have the special permit process where a lot of this will be addressed, but each department head was at that meeting with the mayor, and this was just for letters of non-opposition. So maybe we should consider getting our department heads and our police and fire and everybody in from the get-go, because I could tell you, recently I spoke to a police officer down at the Stonewood Tavern, and I told him that we were going to hear this on November 9th, more than likely. He had no idea that we had even done this. So I think it might be good to have at least, maybe we don't want their input at that time, but at least to have them involved or invited right from the get-go, so that everybody is on the same page and everybody knows what the discussion was, so that when we do come for the special permit, we're not answering the same questions twice. Just a thought, and I guess I could open that up to the rest of the council.
Councilor Manning Martin?
Thank you, and I apologize if I'm asking questions that were already addressed. I was running a little late. But, so we're going to meet on the 9th for presentations, November 9th, and then we're going to recess and take a vote. Is there going to be further discussion on the 16th?
The 16th would just be a vote, no further discussion.
Okay, and there's mention of a matrix tonight, and I know that you had mentioned something that may have been the reference of a matrix at the last meeting, but I thought that the advice of the city solicitor at the last meeting was that we should be as liberal as possible in the approval of these letters of non-opposition. Was that correct at the last meeting?
That was the description that I used.
Yeah, so I guess, where's the matrix coming in? Could you explain what I don't know what the matrix is that we're discussing tonight.
I was using that to describe the protocol that was suggested by the council president before you arrived. You know, for the presentations, the amount of time allotted, the amount of time for question and answering, when to reset, when to deliberate, when to recess, when to undertake the final votes.
Okay, so it wasn't like a matrix that we're going to use to base the criteria of whether or not we should approve or deny the letters of non-opposition?
No.
Okay,
correct.
I was confused with that. Thank you. And we're going to hear it on the 9th, and then there's not going to be any further discussion. We're just going to vote on the 16th. Why wouldn't we vote on the 9th?
Well, I feel that it's something that, as previous councils have said, and I'm in agreement, I think it's something that there's going to be a lot of information that night. It allows you as a council to do your research, because you're going to be voting on 3 separate entities. And yeah, you can do your research beforehand, but there's going to be a lot of presentation. I assume there's going to be some things that might be said that night that you might want to do some fact checking, you might want to do some background, whatever you feel your due diligence. So that's why I feel that it's appropriate to put it off for a week. Now the reason you can say, well, why don't we put it off for 2 weeks is, unfortunately, we have a calendar. And the calendar, we're looking at possibly 2 meetings in December. And I do feel that, I don't feel we have rushed it. I do feel that we are giving our due diligence. As far as the 16th, Councilor, I'm open to discussion. If the, you know, the council as a whole, the subcommittee would like to, you know, be able to ask discussion, I guess maybe, I would assume the discussion would be, I don't know if you'd want to be able to ask the three parties, you know, I'm open to that. I guess, you know, I really don't have an issue with that at all, in that regard.
Sure, and my reason for questioning that is really twofold. That I'm not familiar that we use that process with anything else that comes before us. So that makes me uncomfortable to just have this one, you know, it is an important subject, but we have a lot of important business that comes before this council as well. That isn't any I don't think any less important. So we just haven't done that before, so I'm a little uneasy about taking a week break and then coming back. The second reason is I'm not going to be here on the week of the 16th. I'm out of state, so I'd like to vote on it, and but I'll just put it out there. I'm not going to be here, so the council, of course, can move on without me, but I won't be here. I will be here on the 9th, and again, it's just a different format that we're taking that we haven't done before, and I guess I'm just not comfortable with that. Splitting the vote and hearing it later. Hearing it and then voting later. Thank you.
Councilors, anyone else? Councilor Walsh.
Yeah, Mr. President, the only other concern I have is the discussion about the host agreement. I do have some reservations about us holding over an applicant's head. What are you going to give us before we issue that permit? So I guess I'd like some advice through you from our city solicitor, just on what the guidelines are. There's just an uneasiness with me about that. You know, if it seems to me if the person or the party is qualified and we decide that the applicant warrants a special permit, that the host agreement, which is going to be negotiated between that party and the mayor, maybe should not be factoring into what our decision is. It just seems to me that we're almost, you know, kind of, well, I'm not sure it's the direction I want to go.
If you look at the legal commentary, especially at the very beginning of, you know, the approach by Massachusetts to recreational marijuana and medicinal marijuana, you'll probably recall seeing many headlines, you know, pay to play, and how obnoxious and offensive to our system, you know, that particular aspect of what appeared to be part of this approval process is. So I'm agreeing with you in theory. I think that the limits of asking about host agreements at this stage of the game, you know, the determination and the collection of evidence relative to letters of non-opposition or support, you know, can fairly be, what do you generally envision to be your relationship with the city vis-a-vis a host agreement, and or your relationship with the other aspects of, you know, the community. You know, we have a long history of companies coming in here and talking about, you know, having a certain percentage of their workforce coming from Peabody, et cetera, and et cetera. I think it's a fair question just to have an open-ended question and just see what they have to say. But as far as the nuts and bolts of the host agreement and the negotiation, that's left for the special permit process. So I think I gave you half the calf.
I think you did, Mr. President. I feel a little bit better. I still have some concerns, but I guess I won't be here for the special permit from the sounds of things. But I honestly don't think that the host agreement should come into play on whether, if an applicant qualifies, or we think as a council that one or two or three of the applicants go forward to DPH, I think that the host agreement should not be part of that issue. You know, we'll leave that for later. That's something that's negotiated from the corner office. What we really need to be looking at on the 9th and the 16th is, does the applicant qualify in our eyes to move forward to the next hurdle, which is DPH. And then they have several things. All three may not come out of DPH. One may. You know, we may not be issuing 3 letters of non-opposition. But I just think the host agreement piece of it should not be part of our discussion that evening.
I agree with you. I never thought it would be, just from my perspective. I didn't expect it to be, other than the fact what the law was, which I believe is 3% of gross. I did not intend, personally, of asking any question about the host agreement. I didn't feel it was appropriate, so. I'm in
Okay,
agreement with
I
you
feel
there.
better about that. Maybe I misunderstood, but I thought that was discussed a little bit in our conversations over the last couple meetings, but I'm happy to hear that. I feel much more comfortable going forward, knowing that piece of it would be down the road and not in the upcoming meeting.
I'm in agreement with your counsel on that. Counsel Gould.
Thank you, Mr. President. I'm in agreement with Councilor Walsh. However, I just have a issue about what comes first. Does the mayor negotiate a host agreement after we approve the special permit? Or does the mayor get a host agreement from any of the applicants? Does it, in other words, should it play into our decision that Company A offers more educational support for the Peabody Public Schools than B and C? And is that something that the mayor, when he negotiates it, lets us know, Mike? Is that, does it ever get
can be
discussed?
simultaneous with your undertaking the decision on this special permit. It can be simultaneous. Yeah.
Simultaneous meaning that we approve the permit and the mayor reveals the host agreement, or that we approve the permit and the mayor then goes and negotiates a host agreement?
I would envision, one possibility is that here is an agreement that's been formulated in theory. It's been reduced to writing. It is not executed, but if the special permit is granted, the parties agree that this is what it's going to be, so that you'd have it as part of your package.
Is that what you were, through you to Councilor Walsh, is that what you envisioned, Councilor Walsh?
Through you, Mr. President. I envision the first part of it not being a discussion, and I think we've pretty much established that's the case. The part of the special permit, I still have a little bit of an uneasiness. I think if the party comes back and they've made it through DPH and they come before us, we then have to look and say, does this person meet the requirements of our special permit requirements? And if they do, I find it very difficult if I was sitting here to say, I'm not going to vote for that because you're not giving us enough in your host agreement, where if we have a second party, we like them a little bit better because they're giving us a little bit more. I just have a little bit of an uneasiness about that, sitting in this position.
Mr. Chairman, through you to Councilor Walsh, so do I. And so I think before we're meeting here tonight to determine all the, as Councilor Manning said, all the steps to take, the matrix. I think we need to figure out, where does that come into play? When do we look at the host agreement, which is negotiated by the mayor and not voted on by us on, I think it doesn't get voted on. The special permit, gets voted on regardless of what the host agreement was. I think, and when does the mayor negotiate that? If we're setting the guidelines, I think we ought to talk that out. Does the mayor negotiate that after we approve the applicant or applicants? I don't know, Mr. Chairman, help us here.
Sure, absolutely. So the negotiating of the host agreement is not going to occur, any conversation between the mayor and the party, until they come back with the approval from DPH, Department of Public Health. That is 100%, because we're not going to get into any host agreement if they're not qualified and they don't get it from the Department of Public Health. So that's the first step in it. And the tricky part and the tough part, which I believe we all struggle with, is the unknown. And what I mean by that is that we're looking for a finite understanding of we're going to have 1, 2, or 3. And as the city solicitor said to us, I can't give you that answer. It could be 1, 2, or 3. So as I understand you want the answer, we don't know what's going to happen. If one came back, then the mayor would negotiate the host agreement. I, as I believe some other councilors said, think that we should know what the host agreement is before the special permit hearing. I don't think that's a bad thing. I think it's public disclosure. Now, let's just say, for argument's sake, if it's 1, it's kind of easy. But now, if we get into 2 or 3, that's where I understand when we get into a little bit of those sticky waters, so to speak. Understanding, I didn't set the process up, city solicitor didn't set the process up, this is what we're faced with. So now, let's say that 2 people get the letter of non-opposition, or greater than 1, we'll say. At that point, I feel that the mayor would negotiate with them, and once again, I wouldn't feel comfortable. I know that it's been kind of underlying tones tonight, and I know previous council at the previous ad hoc committee talked about the uncomfortableness about trying to, what are you going to do? What are you going to do? The bidding against each other. I don't see that happening in regard to the fact that I think the integrity of the process with the mayor involved, I'm comfortable with that. That being said, as a councilor, I'm going to vote on a special permit. I do think that we have a right to know what the host agreement was that was negotiated. So I don't think, you have to have, I don't think it's a leap of faith, probably not the best terminology, but I think you have to, it's kind of the chicken versus the egg. We have to start something first. We first have to decide the letters of non-opposition, let them go to the state, come back to the Department of Public Health with that letter, and then we know they're going to go for a special permit, and if they fill out the special permit application, then that gives the mayor the authority to then enter into a host agreement negotiations. If it's 1, if it's 1. If it's 2, if it's 2. I can't predict that. I understand people are uncomfortable with that, but once again, it's a process that this body didn't set up. It was set up for us to have to navigate. Councilor Charest.
Thank you, if I may. Would it make sense to have the host agreement created before, and it's for all 3? That if the mayor creates this host agreement, it would be up to the applicants to agree to that host agreement, that it's standard for if it's 1, 2, or 3. So people can't say, you made a special deal for A, B, or C. The mayor, you have it already set. Just asking a question.
Personally, the terminology that's been used is the mayor will negotiate a host agreement. Negotiation,
Thank you for deferring. And I do want to address you, Councilor Charis and Councilor Walsh, and hopefully put a little, confidence in the council over the angst for host agreements. When the legislature, that body that you work for, and the governor did the final amendment to the medical marijuana and recreational marijuana provisions that became effective in July, they sent a sledgehammer of a message. And they just said, listen, we don't want to hear it, about these, freewheeling, open field running deals with host agreements. You know what? Communities, you can get your 3%. And I'm just going to make a prediction. I'm going to predict that whoever comes back to us, whether it's 1, 2, 3, or whatever the combination, they're all going to say, hey, we owe you 3%, that's it. And I say that because we've been down this road. We've been down this road when we reset the special permit fees for the billboards. And as you well know, when the ordinance was originally passed in 2011, it was like $1,500 and $2,500. And now we're staggered at $25,000, $20,000, and $15,000, depending on where you are and what type of board you had. We had every company in here. We had a big round table. they all huddled. They were all competitors. They all huddled and said, guess what? This is tops, that's it, but forget it. And I'm going to make a prediction that every company that comes here in any other municipality is going to say, you know what? That specter, that goblin of pay to play, we're going to help extract that out of the equation. That's what I think is going to happen.
Council Gravel.
Yeah, thank you very much for that interesting segue into billboards, because that was going through my mind as I was listening to the discussion, because I recall back in 2011, in the waning days of a term, there was, we were into December and close to it, and all of a sudden, that interesting little piece made its way back in on a last meeting of a subcommittee with very little discussion and not a lot of working through the detail. And so, as we approved it, we then got to live with whatever the ramifications were that we hadn't thought about at that period of time. And I only bring that up because here we sit at, you have a final election coming up. I know when I was on the school committee, we never took a substance issue like this and voted it in the last part of a term, because whether we want to believe it or not, there's a chance that there'll be 8 new bodies sitting on this council in January. So I guess if there's angst amongst the councilors, are we under a clock to have these hearings, make these decisions, and send them to the state, and then deal with the ramifications that perhaps 8 new councilors have to live with? So just asking the question is it proper for us right now? Is it in the best interest of a policy-making group to be thinking about these types of issues, which have a longer impact at the end of a term and before an election cycle, which may determine a whole new body, which then may have a whole different opinion on whether or not we even deal with it? So just asking the question, would like the answer.
Would you like to state your opinion on that?
You're under no time constraint. And quite frankly, when, President Sasslaw outlined a procedure for the body to consider, my commentary was, well, look, it's not inconsistent with our ordinance, the zoning ordinance. It's not inconsistent with state law. It's not inconsistent with the state regs. It's fair. It gives, the council time to deliberate, and there is flexibility in obtaining the information that's necessary. I mean, so in terms of, well, it's legal, but as to, what speed and what steps that you want to take, at a particular rate, that's a legislative determination.
Thank you. Just to respond to that, because I think that is what I was looking to hear, in that, we approach this subject like, let's just get it over with, and I have no problem with it. I mean, in terms of having hearings and such, but if what I'm hearing, and there's a lot of, and I apologize, I was in Ms. Manning's traffic as well. Thank you, Salem. If there's an angst or any kind of a concern that we haven't thought through a process, or maybe we want to see more communities exercise a process to kind of get a sense for, what's going to go down and what's going to happen, then if we're under no time constraint, I just don't understand why we would not continue to work it through and discuss it and come up with something that everybody's comfortable with, and let that be a part of the January through to December's later term of whomever is going to sit on this board, and not have to be concerned with, because you just heard, he may have to vote on an application that he'll never get to see the special permit on. This one, same thing. That one, same thing. So it's kind of an odd time to try to, really push it forward hard. I'm just thinking it might be a time to step back and reflect, because frankly, having gone through the billboard debacle, I don't want to go through that again. And I remember I was the one who kind of pushed it through that night, because we were going to get that zoning done and come hell or high water. But, it kind of was a little bit of a, got to live with a little bit of regret afterwards that we didn't put any constraints on it. We didn't put any restrictions on it. And the next thing you know, we became Billboard City, and 20 applications and all sorts of things occurred. I just think it's, if there's any concern that anybody has in terms of wanting to reflect on this, I want to know for sure that, and you just told me, time is not of the essence here, so, my opinion.
Councilor Turco, did you?
Thank you, Mr. President. First, I just want Councilor Gravel to be confident that I'll be here January 10th, so.
You're the only guarantee.
So,
There's only 2 guarantees.
the 3 of us will be here anyway. My concern with that, and I may not be justified in it, I'm trying to think of the other cities in Essex County that have applications before them, and I think Salem, Lynn, Danvers. So I guess, Mr. President, through you to the city solicitor, since there are only seven being dedicated to Essex County, do we run, I do agree with Councilor Gravel wholeheartedly, but do we run the risk of being last man in, and we lose one of those 7 permits because we waited a little too long? And we've done that in the past, and, I think, I could be a little impatient at times, but I don't want to lose out on, we've done all this work, we've set the zoning, we've done everything that we can do, and I do understand that's going to be a tough situation where some new councils come in and vote on a proposal of this magnitude without being privy to that. But that being said, most of the new councilors will be here, as we were when we were new councilors to the prior meetings. So through you to the city solicitor, Mike, is there a chance that we could lose out on one of those 7 because we've waited too long?
Yes.
That answers my question, so thank you.
Councilor Manning Martin and Councilor Gould.
Thank you. And through you to Councilor Gravel, the meeting on the 9th that we're going to recess and then vote on the 16th is only for letters of non-opposition. Is that correct?
Correct.
Right. So it's the letters of non-opposition, which is really, I think, their first hurdle for these 3 entities to get going and doing, what they need to do. It's really just to give them the green light to move forward and go to the DPH. So I agree with you wholeheartedly on that we want to implement this in a fashion that's not a breakneck speed, that we don't do it right. But I think this is just for the letters of non-opposition, which the city solicitor has already advised us to grant in a liberal fashion. I think it is not a problem. That's one thing. And then with respect to the host agreements, I would concur with the city solicitor that I think the host agreements are pretty much boilerplate at this point. I don't think you'll see much fluctuation from the ones that they have in Salem and surrounding communities, Gloucester. And lastly, maybe through you to Tim, since if the council continues to go forward with the hearing on the 9th and then the vote on the 16th, and as I said, I won't be here on the 16th, since this isn't the normal course of business, will I be able to vote in absentia because I will have heard the testimony? Will I be able to vote? As opposed to how normally if you miss the testimony and it's recessed and continued, then you can't vote because you've missed part of the public hearing.
If it's deferred to a later meeting?
No, if we're going to, if it goes forward as described this evening by the city council president, if we have the three parties come in and have a hearing, and then we recess, and then there's no more discussion at the next meeting, just a vote. It's been divided into one meeting to hear, and then the next meeting to only vote, no discussion. Will I be able to vote in absentia?
I don't believe so, Counselor. On the 16th, no. Because you aren't going to be here. You have to be present to vote.
But we've never done this before, so normally you can't vote if you haven't heard that you didn't have the public hearing. Are you chomping at the bit, Smuzz? All right.
Go ahead, Mo. Go ahead.
Surprise, this could be good news for you.
I already agreed with you once tonight.
I thought a lightning bolt hit me, but
We can only hope.
there's new rules for the open meeting law that permit for telephonic participation. I have to double check it, and unless you're wrapped in rubber, so there's no conductivity from the lightning bolt hiding on a Caribbean beach, not Puerto Rico, with a cocktail with a plastic umbrella in it. Yeah, I think you may be able to participate that way and vote. But I'll have to confirm that with the clerk.
Thank you.
Council Gould.
Thank you, Mr. President. I was the one that mentioned 7 sites in Essex County. I'm not sure if I heard that or how I heard that, or I'm double guessing myself. I'm really questioning myself. Does Councilor Walsh, through you to Councilor Walsh, do you know, Councilor Walsh, how many permits are going to be issued in Essex County?
I'm being told by the city, it was part of the original legislation, correct?
It is definitely only 7, Mike?
He does not believe there's been any change, but it is a finite number. He believes it is 7.
Okay, thank you.
Go ahead, Tom.
Just one quick suggestion, Mr. President, is if Councilor Manning Martin is unavailable on the 16th of November, why we just not push that out to the next meeting so that we accommodate her unable to be here, and then you don't have any question about whether the vote is legal or not from off-site.
So let me go back to that. Let me just throw a few things out there. You know, the angst I hear, and I'm hearing it, and I know Councilor Gravel alluded to it too. I don't think it's. First of all, I don't think we've rushed the process. I think we're taking our time with it, and I'm willing to talk and extend the calendar after what came out from Councilman not being here. I think what does not happen, though, if we extend it to next year, is there's no change in the law, the ordinance. It is what it is. The angst people are having is the unknown of the host agreement, and seeing that, and having to make a vote. I don't see that things are going to change, and there's going to be amendments put in and things of that nature procedurally. So I'm not so sure, and I don't think I was there the meeting, that last billboard meeting where some things was changed in language. I don't think with this issue that can happen. It's pretty firm on what we can do and cannot do. So I just think that, you know, we've spent a lot of time, we've done the ordinances, and I think that until we get those letters back from the Department of Public Health, we're still going to have some angst, and we might even get them, if we have 2 or 3, you know, the people who are on that council are going to have to make that vote. And with technology, for the councilors who are new, well, they'll be able to go down to PATV, and they can get a copy of this meeting and any other meeting and read it. So I don't think extending it, I think we have a job to do, and we should do it, and we should take our time doing it and do our due diligence. And I think I've tried to make that happen. What I would suggest is this, is we have a very, very, very busy meeting on the 9th. We have a lot on the agenda. What I would rather suggest, but there's always going to be someone who's not going to be able to make the meeting. So that being said, you know, I'll throw out this to the council. We could push it back to the presentations on the 16th, and then the 16th of November, and then when we have the next meeting, which is scheduled, the 16th is busy. Okay, we can set up a separate night for hearings. I mean, I'm hearing we're busy, so if we want to set up a meeting on, you know, I'm open, basically I'm open. I just, you know, when we get into that, this person's not here, that person's not here, I get a little bit concerned with that. But the point I just want to make is I don't have any problem extending it, but I would like to see this council make it. I think this council has done its due diligence. I think we really have. I don't want to see us lose out on, you know, revenue. You know, that's a, you know, it's election season, absolutely. And what's the number one question that all the press asks us? How are you going to generate revenue to keep the tax stable rate in Peabody? Well, I would hate to see that opportunity go by. Council Gravel.
Well, if that's the case, then why don't we just do it on the 9th? We'll have the people here. It's kind of a perfunctory function anyway. Why not just vote it on the 9th? Hear them, vote them. That way it's not fading in your memory, and the only thing that they can then do is they can run to the state and fill out their application. The state will do their diligence, and then they'll have to come back and do a special permit. So, yeah, I mean, you put you put any fear I had at ease. If you know, I just think basically, I don't even understand what we're going to be doing that extra week thinking about it. I mean, we're going to hear it. You're going to know. I mean, yeah, maybe you can do some research, but outside of that, the state's going to do the same research, and they're not going to get a license or an ability to come get a license unless they prove those things to the state. So, to accommodate Ms. Manning's schedule and to ensure that this gets done the way you want it to get done, I'd make the motion to make it on the 9th.
Thank you. And what I'd like to suggest, part of that motion, going back to the concern of Councilor Turco, is I'd like to make the motion that the presentations will be done by the three parties on November 9th. They will be given a 25-minute time slot to make their presentations, and then afterwards there will be a brief question Q&A by the council, and I will not put a time limit on that. If everyone's comfortable with that, if we can get a motion from the floor and the subcommittee could vote on that. So the motion would be that on November 9th, the three parties will be invited to come to make a presentation before the council of the whole at the regular meeting that evening, and then there will be a 25-minute time limit on their presentation, followed by a brief Q&A of each party by the councilors as a whole, and then after all three presentations have been made and the Q&A has happened, then each group will have a vote for the letter of non-opposition. So moved. Roll call vote, please.
Councilors Gravel, Turco, Gould, Walsh, Sasla.
Yes.
Motion carries 5-0.
Thank you, councilors. We're going to have a brief, Councilor Turco?
Mr. President, I don't know if you want this in the form of a motion, but I would also like to send out notice of that November 9th meeting to all department heads, police, fire, community development, health department, and any other departments the mayor sees fit or you as council president see fit.
That's an excellent suggestion. Thank you. You've heard the motion. All in favor? Any opposed to vote?
Motion to adjourn?
Motion to adjourn. Brief 5 minutes. We have Dr. Lupini. We're running a little